Hello, everybody. So, today we'll be delving into an important Supreme Court judgment which has been announced yesterday concerning permanent establishments in India. Hyatt International Southwest Asia Limited versus Additional Director of Income Tax. This judgment, it provides crucial clarity on the presence of permanent establishment of foreign companies operating in India. It delves on the nexus principle, and it also discusses the taxability in case of global losses. So it discusses fixed place permanent establishment. It also discusses whether when the employees are present in India, then what conditions need to be met, etc. So let us look at it. So coming to the background of this particular case, the appellant, which is Hyatt International, is a company which is based in UAE. The core legal question before the Supreme Court was whether Hyatt had a permanent establishment in India. So Hyatt has entered into Strategic Oversight Services Agreement, which is SOSAs, with Asian Hotels Limited in 2008. The purpose of this agreement was to provide strategic planning and know-how for high-quality hotel operations. Now, Hyatt claimed that no PE existed. Since it did not have a fixed place in India, it was just providing consulting services by way of SOSAs. Nor any employee visits exceeded 9 months in a year, which was the condition required under the India UAE DTA for a services PE. So the key question before the Supreme Court and before the lower tax authorities was essentially that does Hyatt have a PE in India to which profit will be attributable? So now let us look at the brief history of the assessment, the litigation of this particular assessee. So the assessing officer disagreed with Hyatt's stance that there is no PE. The AO concluded that Hyatt's activities did indeed constitute a PE under Article 5 of the India UAE DTA and also established a business connection under Section 9 of the Income Tax Act 1961. The income was also initially classified as royalties and fees for technical services. These findings were upheld by the DRP and the ITAT. Hyatt then appealed to the Delhi High Court. The Delhi High Court ruled in Hyatt's favor on the issue of royalties. But critically, it held that Hyatt did have a PE in India due to its extensive operational control over the hotels. Recognizing the complexity of the global losses aspect, the High Court referred this specific question to a larger bench. The larger bench ultimately answered in the affirmative, stating that profit attribution to a PE is permissible regardless of the enterprise's global financial losses. Now, this paved the way for Hyatt to appeal to the Supreme Court, and therefore this particular judgment. So, before the Supreme Court, Hyatt reiterated its core arguments regarding no PE existence. They maintained that they provided only consultancy services operating from UAE and therefore had no fixed place of business in India that would qualify as a PE. They also emphasized that their employees' visits were brief and did not meet the 9-month threshold, often stipulated in Article 5(2) of the DTA for a services PE. Essentially, their position was no PE, no tax in India. The revenue, on the other hand, strongly countered these arguments. They contended that Hyatt's role extended far beyond mere advisory services. They argued that Hyatt was involved in active and significant control over the hotel operations. This was supported by the long-term nature of the SOSA and the consistent presence of Hyatt employees, suggesting a deeper operational involvement than what Hyatt claimed. Now, coming to the Supreme Court's analysis and key findings. So, the Supreme Court meticulously analyzed the facts and legal principles. They firmly rejected Hyatt's arguments, observing that the SOSA documents themselves granted Hyatt extensive powers. These powers included the authority to appoint key personnel, set policies, and manage the finances of the Indian hotels. The court clarified a crucial point regarding the definition of a fixed place PE under Article 5(1) of the DTA, which is exclusive possession of a physical space is not a prerequisite. Temporary or even shared use of a physical space can suffice if core business activities are demonstrably conducted from that location. The court also referred to its earlier landmark ruling in the case of Formula One World Championship, which established that a PE requires stability, productivity, and dependence. The court found that all these criteria were met by Hyatt's 20-year agreement and its deep operational involvement in the Indian hotels. Another key finding is related to the frequent and regular visits by the employees. So rather than the duration of individual stays as being a key factor. So the court held that once continuity of business presence is established, the return or rotation of individuals becomes irrelevant, and operational control, oversight, and income linked to core functions establish a commercial nexus necessary for a permanent establishment. The Supreme Court finally held that Hyatt had a fixed place PE in India under Article 5(1) of the DTA, and that the income received under the SOSA is attributable to such PE and is therefore taxable in India, irrespective of the fact that there were global losses. So the Supreme Court judgment is highly significant. It definitively holds that a foreign company exercising significant operational control through local subsidiaries in India constitutes a permanent establishment, thereby making its income taxable in India. Crucially, this income is taxable even while the foreign company is globally incurring losses. So this ruling, it reinforces India's sovereign right to tax foreign entities with a substantial operation or presence in India within its borders. It places a strong emphasis on substance over form in determining the existence of a PE. For multinational corporations operating in India, this judgment necessitates a thorough review of their existing structures, agreements, and the extent of their operational involvement in their Indian subsidiaries or affiliates. It underscores the vital importance of a detailed analysis of the DTA provisions when structuring cross-border operations and the applicability of the DTA provisions to the particular case. Thank you everybody for watching this update. Let me know if you have any comments or questions in the comments below. Thank you so much.